Well, welcome to the Regent Law Podcast. My name is Ernie Walton, the Interim Dean here at Regent Law School, and it's my privilege today to host one of our newest law professors, Associate Professor Jeremy Christiansen. Jeremy, maybe you can just tell us a little bit about yourself before we jump in.
Sure. I just recently joined the faculty this past summer after an 8.5 year stint in private practice in the Washington, D.C. area, where I practiced constitutional and appellate litigation, administrative law, intellectual property, and general commercial litigation. I graduated from the S.J. Quinney College of Law at the University of Utah, and I spent some time clerking for the Honorable Thomas Lee on the Utah Supreme Court and the Honorable Jay Bybee on the U.S. Court of Appeals for the Ninth Circuit.
Well, great. Jeremy, Professor Christensen. Today, I think we're an amazing cultural moment, and particularly within the conservative legal movement itself. For the past 40 years or so, we've been, at least in the conservative legal movement, really dominated by the legal theory of originalism. But it seems there's a shift, particularly among the younger generation, more towards the classical legal tradition, the natural law. And so that's really what I want to chat with you about today. And so to start us off, what is natural law and what is not natural law?
Yeah, I think natural law gets. Let me start with what it's not, because you hear maybe popularly a lot of different things that are incorrect. So one idea of natural law is sort of, well, whatever it is that we happen to observe in nature, or whatever we happen to observe that humans or animals do, that this is some species of natural law, that's what we mean, and can trip people up, particularly when we get to, the most important component of natural law is generally an aspect of how we think about moral questions and legal questions. And so people might say, well, why would this be contrary to the natural law? I see, animals engage in this behavior. You could think about murder. Animals kill each other without just cause or something all of the time. Why would we think about natural law that way? So it's not a question of a thing that happens to exist in natural reality. That's natural law.
Yeah, that's a helpful clarification. I think just because we see it doesn't make it the natural law. At least getting that off the table.
Yeah, and then I think, by another token, it's not, the natural law is also not, uh, while it is all encompassing in one sense, um, it is not some sort of general, very particularized set of conclusions about everything in our world and in our life, from which we are going to have concrete answers about everything. And so, sort of, those are the things that it's not. What it is, I think, is more interesting,
Sure. Yeah.
and comes to us from a really interesting tradition. I speak about it as the classical legal tradition, and that's thinking about the term of how it developed in a juristic context, in the rough and ready world of, like, the law and real politics and real governmental systems and adjudication of legal disputes.
So just
Oh,
to clarify, would you say then the the classical legal tradition is the application of natural law to the legal system? Is that fair?
yeah, I think that's fair. I think it is it's at once a philosophical system, um, and at the same time a legal theory. So, sort of, it's both at the same time, and I think also in conjunction with that, it tells us not only what the law is and is not, but by virtue of telling us what the law is, because of some of the metaphysical presuppositions of natural law thinking, it also tells us a great deal about how we ought to read and understand and interpret law. So I think in that sense, it's both a theory of what the law is and a theory of how to understand or interpret the law. And it comes down to us in two important strains, particularly as we think about the question here at Regent. On the one hand, we have the development of this thinking in pre-Christian, in the pre-Christian world, or for people who do not have divine revelation yet, right? And this comes out of the thinking of philosophers like Aristotle, Plato before him, but developed greatly by Aristotle, by Roman Stoic philosophers, and it's through Stoicism that these underpinnings find their way into the legal system, for the way that people think about the everyday ordinary law. And then on the other hand, we see this same tradition picked up in the early church, in the New Testament, of references like St. Paul's to a law written on the hearts of the
Right.
Gentiles against which they can be judged about matters of right and wrong. And the core idea of the natural law, and this gets to the first question of what is it not, is that when we say this, it's to say it is the law that we can discern by reason, that flows from the nature of things. And when we say the nature of things, we mean something kind of particular about what is our reasoned investigation about, for example, the nature of a human being. What is it to be a human being, essentially, and what is it not? That it's through unpacking that question that these thinkers start to discover precepts of what they would call the natural law, that there seems to be an essence of what it means to be a human being, that is a rational political animal. And the thing that makes us different from the other animals is this gift of reason and will that we have. And from this sort of a reasons system of thinking that says, well, the nature of a person, to live rightly, is to act in accordance with your nature. So
Sure.
one example I will give, a sort of Platonic example, is not quite normative, because we're not talking about things that are subject to moral choice. But if you think about the idea of a triangle, okay, there's an essence of a triangle. A triangle is a thing that Plato would have thought exists somewhere, essentially as this two dimensional planal shape, three sides, and its interior angles add up to 180 degrees. That's how you know that it is a triangle and not a square or a
In
circle.
essence, that's what a
Yes,
triangle is. Yeah.
that's what it is. And I could draw a triangle, say on a whiteboard, and we would say that this exhibits the essence of triangle to some degree, but we would notice imperfections, right? My lines aren't perfectly straight, or the angles wouldn't, if I got a protractor up there, they
Sure.
might not actually be there. And then we can make a judgment about that triangle. We could say, I could draw 10 triangles and say, some of these are better triangles than others. And how do we know this? Well, it's with reference to the nature of a
Sure.
triangle. The closer that a thing approximates its nature, the better something is, and it gives us an objective criteria for judgment. And then when we apply this, right, Aristotle starts thinking about these questions, obviously in a somewhat different way than Plato does, but starts thinking about these essences in things, and says, well, gee, there's humans. Is there a human nature? What does it mean to be a human? What is the essence of a human? And it seems that the kind of key criteria is this thing about reason and free will, um, such that we can make a moral judgment about living rightly or wrongly in accordance with our nature. And we can take that frame of reference and apply it to particular human actions and make objective moral judgments about them. And this is kind of the essence of natural law thinking on that score, sort of where it originates. The more full answer to the natural law, of course, is that as people think about this, and as these ideas are developed over the centuries, the Stoics and um, these philosophers start to think about, well, it seems there's some kind of like eternal law, some kind of overarching principle of rationality and coherence that's all around us that makes life intelligible. And from this eternal law, it's like it's imprinted on the created world, and you get in the Christian tradition a development of these ideas that locates this eternal law in God, that it is like God's perfect, plan of how things ought to be and will be, emanating from His mind eternally. And in creation, that is, the word that gets used is like stamped. Augustine uses this terminology, and
God's eternal principles stamped on the creation that he, on the created order.
exactly. And so they're not. It's different from the stamp, right? It's different from the stamp, but it reflects and sort of, as they would say, participates in it.
Mm,
And then the natural law is this stamp on created reality, that because we have access to reason, that we can discern this stamp on created reality and reason out of that. And this is the principle of the natural law. And the natural law tells us certain things very clearly, certain primary or first principles or precepts of the natural law. We can think about, not taking innocent life, or our own motive to self-preservation, right? To live rather than to die, as a general matter. These kinds of first principles, to procreate, to educate children, to know the truth. These are sort of these first principles of the natural law. But as it requires more of our reasoning to sort of think through, okay, well, what does the natural law have to say about this particular circumstance or that particular circumstance? What side of the road should I drive on?
sure.
The principles become clouded through lots of facts that our imperfect brains have to, absorb and think through, and contingencies that we don't have perfect information about. And then we also know, as Christians, that we suffer from a defect, by dint of the fall, that makes our reasoning, not quite capable of what it ought to be. And so God, of course, has given a great aid in discerning certain principles of the natural law through what we call divine law, that is, the scriptures.
Yeah, and would you say the divine law is part of then the natural law, or they opposed to one another?
They're not opposed to one another. To say they're a part of, I could say yes in some sense, no in another, and that they're distinct in that natural law is something that, at least in principle, humans are capable of discerning through unaided reason
Sure.
alone. Right, and so, St. Paul can rightly say, the Gentiles can be rightly judged about a number of moral matters because this law is imprinted on their heart. They don't have divine
Even
revelation.
though they were never given the law at Mount Sinai, right? It doesn't matter. God is just to still judge. Interesting. Yeah.
Yeah, and on that point, on the Ten Commandments, the early Christian writers were adamant that the natural law is entailed in the Decalogue. That these principles, don't steal, don't murder,
Right.
etc. That these are principles of the natural law, and this gets to this point about what we do with uncertainty or difficulty, and it introduces the important principle of both divine law and human law. That um, God in his greatness, uh, gave us the divine law to aid us about particular things, including things we couldn't have arrived at, obviously through reason, certain supernatural truths that we would not know. But the natural law tells us we owe, in justice, worship to our Creator, and there's going to be a lot of error about exactly what that entails, right? But God, through divine revelation, gives us, this is how it is. This is my nature, insofar as God is going to reveal it to us, etc. And so it's a sort of posited, um, part of the law in that sense. Human law is this really interesting thing, because it's a way, we see in the animals. The classical writers will say the animals, they carry out the eternal law in this particular way. They don't have will, they just do it. Animals act the way they act in accordance with their nature, because
Without
God made
having to
them.
try. They don't have
Yeah,
to choose. Yeah.
they don't choose between things. But God has given to us this great gift of reason and
Mm,
will, where we get to choose our participation in God's eternal law, which sets out how we ought to live, allows us to choose and use our reason to participate
mm.
in this. And so, in certain matters, there are, great contingencies and unknowns where we specify the principles of the natural law to some contingent circumstances, right? The A classic example that contemporary writers talk about is what side of the road you're going to drive on, right? So we'd say, well, we know that the natural law tells us human life is very important. We need to protect it. Now we have these great things called automobiles, but we also see that they are dangerous potentially to us, and that some kind of order needs to be imposed. We can't just have people, driving however quickly they want or on
Wherever they want, whatever side of the road, we need some order. Yeah.
exactly some kind of order in order to um, be in keeping with this principle of the natural law. Uh, and also, sort of relatedly, a related concept of what's called the common good. That we are by nature social, political animals, and we live in communion with one another, and that we have distinct sort of transcendental goods that exist among us,
We're not
and that
autonomous beings unto
correct.
ourselves. It's just in our nature. We're not that, right? Is that sort of what you're saying?
Yeah, in our nature, we are not autonomous, sort of radical individuals. We are social, political creatures, and that is for our good. Our ultimate good, as we know, is in the body of Christ. Is to be, this idea of sort of corporate
Yeah.
salvation, and that our greatest common good, of course, is of God in the beatific vision, to
Yeah.
worship and adore Him forever. But we also have temporal common goods that are orienting us to this end. Our ends of both
Mm.
temporal happiness and eternal happiness. And so laws like, okay, what side of the road are we going to drive on? Are these reasoned ordinances for the common good, that are promulgated so we can understand and know them and tell us right for the common good of our society and to live in accordance with reason and our nature. We need to protect human life and be in a orderly society. And so while there's some level of arbitrariness to it, right, it could be the left hand, it could be the right hand, um, but that so long as the kind of fundamental conception of law is met, that it's an ordinance of reason promulgated by those in care of the community for the common good.
And on that note, let me stop you. It sounds like you are quoting our dear friend Thomas Aquinas. Am I
I
correct in that? Yeah.
Yeah, yeah. Thomas Aquinas, right? He synthesizes this tradition and says, when we talk about law in its essence, what we mean is an ordinance of reason promulgated by those in care of the community for the common good. And all law, eternal law meets that definition, natural law meets that definition. And if human laws are to be true laws in the proper sense, they meet that definition too. But if they do, they're binding on us in conscience. We have
Sure.
a moral, binding obligation to obey them, and to disobey them is unjust, is immoral, and this is the theory, the natural law theory for why we have obligations to obey the law. The
Sure.
the reality is they are this beautiful participation that we get in
Hmm.
the eternal law of God to in a sense to work out our own salvation, maybe to
Yeah.
to borrow a biblical phrase there, where we are participating through God's grace in this plan and bringing this proper order that yields these benefits to society, that allows us to live virtuously, to be prosperous, to be just, to have abundance, to have peace and tranquility of order. This is kind of
What a vision you just painted, though. I mean, sorry to interrupt, but
no.
man, what a vision that you painted in terms of our participation when we use our reason to discern the created order and apply God's created order, these first principles of the natural law, to our situation. that in this amazing way we are reflecting God Himself in making human law and why we should obey it when it
Yeah.
meets the definition of a proper law. But what a vision you paint.
Yeah, and it's not me painting it. I would say, this is so old. There's somewhat of an amnesia,
Hmm,
and this is, some of the critique of theories like originalism or positivism. That originalism is, at least arguably, in my mind, a member of that family, of legal positivism, but that we sort of forget that these are the best traditions of the West and of our own country. When I talk with my students about this, there's a great line from the Roman jurists, and then it's captured in Justinian's Institutes, where he's speaking to students of the law, and he says, jurisprudence, which is the word comes from, is an amalgamation, right, of use, which is like a hard to describe word, but justice
justice.
and
Yeah,
law. It means a number of things: rightness, and prudence, right? The virtue of wise application. So jurisprudence is kind of the art of justice, as
hmm,
Justinian puts it, and that to be good lawyers,
hmm,
you must, as a prerequisite for these thinkers, must have knowledge of both God and man.
hmm.
And if you don't have knowledge of these two things, you don't have knowledge of the way things are.
Sure,
And if you're going to engage in the enterprise of justice, you need to know the nature of how things really are, because justice is simply a relation between, one or more persons, um, or two or more persons rather, of what is due between those two persons. But if we don't understand human nature and its reality, we can't really engage in the enterprise of justice. And so for
sure.
these thinkers, understanding the truth about God and the truth about man and our nature is fundamental to the study and the practice of law.
Completely inseparable from this, yeah, from the application of the natural law to the law. You can't separate them out.
Yeah,
Let's move to a little bit, that was theoretical, philosophical. We have to start there. And I think a lot of our listeners and particularly among the Christian community might agree, okay? We believe in this created order, the natural law, but how do we make this, practical, and particularly when we apply it to the legal system and the
sure.
nature of judging? When you talk about the natural law and thinking through the role of a judge, if we buy into the classical legal tradition and the idea of natural law, does this give carte blanche to a judge just sort of doing whatever they want? I've heard this objection.
Sure.
Well, if we buy into these principles, we're just giving any old judge carte blanche to sort of make up whatever they want. What do you say to that objection?
There's a couple. I've heard it myself a number of times, right? So there's a few responses. On the one hand, one response is, do we really believe the natural law is a real thing written indelibly on the heart of humankind, like St. Paul says, or do we not? If it is, it's a real thing and we can know about it. And so the objection, do whatever you want, falls a little bit flat, because we're buying into some kind of premise that these aren't actually identifiable objective principles. And there's, of course, thousands of years of tradition writing on these, I don't know, 1800 or plus years, of
Across
the
cultures and
postulates,
times too, right?
yeah, of natural law. And so that's sort of one level of response. Another one is, the the way that we think about law. This gets to this point of, once we know what law is, then we know how we ought to interpret and understand law. Gets into kind of the theory of interpretation in the classical tradition. So law is an unfortunate word in English because we just have that one word. But in Latin and in Romance languages, you'll find two words that get used, and this comes out of Latin because they have two things that you could translate as law. One of them would be use, ius, right, and that's where we get the word just and justice, right. And then on the other hand, you have lex, lex, um, and where what you find is lex is something like written down law. It's often, statutes
Codified.
codified. It's a species, however, of use.
Sure.
And the classical writers are very clear about this, that there's use, and it is law, and lex is a species of use. And that there's as we kind of discussed, right, for a human posited law to be law, properly speaking, there are certain elements, essential elements it would have to have. And that would be true of any form of lex. It would have to be consonant with first principles of justice and natural law, for example, to be law at all. It presupposes that that's what you're doing when you enact a lex, is that you are specifying the use into some particular thing.
Taking these higher principles and then putting them down ordered
Yeah.
into whatever human situation you want to figure out.
Yeah, but the use is not exhausted. It's
Hmm.
not done with its job at this point, right? It's not that, well, there's these principles up there, and now I make lex, and now that's just my law. Rather, to understand what any particular lex means. So this is a question where I will start to take some umbrage with the objection that was given, or with positivism and originalism sometimes, is that they presuppose a particular framework for the question, what does this law mean? And for the classical tradition to ask, what does this law mean, was not to ask, for example, what is the dictionary definition of these words in conjunction with one another? It wouldn't even be, what is the meaning of these words in light of their broader context in a particular statute? Rather, to understand the meaning of lex is to ask how lex and use interact in the case under consideration.
In other words, you don't divorce the text from the use. You just
No,
can't, you're saying.
you can't. You really can't.
Hmm.
And so, people might balk at this. I'd point them to some, really great work. For example, Professor Sai Prakash at the University of Virginia Law School has two really wonderful papers he's put out recently. One is called Spirit, and the other is called The Doctrine of Inconvenience. And they are exhaustive founding era studies of, on the one hand, the use of the so-called horrible, terrible spirit of the law at the founding among all three branches of government in interpretation and understanding and speaking about law. And the other is in this idea of inconvenience, or what we might call dreaded consequences. And I think, Professor Prakash is pretty unanswerable in the fact that our founding generation conceived of law in this classical way. When Blackstone talks about the way we understand the meaning of a legal text, he is very explicit that the spirit of the text, its intendment, its true intendment, its reason, its ratio, these are critical ways to understand meaning. Um, and that this doesn't give license to sort of do whatever you want, right? But it is, I think, a move in the direction of understanding that judges, right, judex, they are the speaker of justice, and they are inherently so because we're dealing with law.
Sure.
Um, that is what they do. They are bounded principles, and of course, judges are not. Um, in the first instance in our system, the determiners of what is for the common good, for example, right? Those are located in the executive and the legislative departments in our system of things in America. And that counsels a pretty high level of deference to them. They are the ones who decide how we're going to specify
To
these
make
principles.
these particular determinations, applying these principles of natural law to the right side or left side. So you're saying we do give deference to the text in the
Yeah.
legislature.
Yeah, but the role of the judge is then to take, right, uh, in this framework, our lawmakers act for the common good and in concert with justice. This should be the fundamental presupposition about how we interpret texts.
Hmm.
And then they have to resolve cases, sometimes hard cases, about that. And I don't think that is a license to, quote, do whatever you want. At the same time, I would also add, as a bit of a critique of theories like originalism or textualism, that they oftentimes purport to tell you that this kind of what we might call judgment of judges is minimized or even eliminated or something under these theories, that judges are only following the text. And I think there's a lot of very strong criticism of this view when you start to unpack questions like, okay, at what level of generality are we to say understand the due process clause or the equal protection clause? Or at what level of generality are we to sort historical sources? You look in the Second Amendment context of the historical based tests of Rahimi and Bruin.
Yep.
How analogous is sufficiently analogous for us to say we can or cannot regulate firearms, for instance? There is what we would call normative judgment at
Within
play.
those questions, you're using inherently these principles of use, right? Broader.
You are. They may be the wrong ones, they may be the right ones, but I think that part of the virtue of the classical model is an understanding that these background principles of legal justice are properly internal to law. We are not engaged in an extra legal affair when we consult what would the consequences of this interpretation be. That is not some out of bounds, you're not doing law. The idea that that is not doing law is a very, very novel one. I think one quite alien to our own founders and our own American tradition of how we think about the law. And so we ought to be forthright about the role that those principles are playing in adjudication and interpretation. And they ought to be the right principles. And this gets, I think, to your opening observation, which is correct in my view, in my experience, about a sort of a desire, a hunger among particularly younger generations of lawyers and law students to move beyond proceduralism and to be concerned with the substance of right principle. That this is a move in that direction. That the law is, I think, inescapably normative, no
Hmm.
matter what theory you have on the table. I think it's inescapably normative, um, and that we ought to just confront this reality rather than try to insist that we can avoid it.
No, it's helpful, and I think we kind of answered this a little bit, but just to make it even more explicit, then, what role does the classical legal tradition, the natural law, play in the actual interpretation of a text? And again, I think we covered it, but I want to make that clear
Yeah,
for our listeners, just to piggyback off a little bit of the discussion we just had.
yeah. In understanding the meaning of any given text, we need to look at what we would today everyone's going to understand by meaning. It's text, it's context, these sorts of textualist kind of tools. But we also have to understand what is the purpose of a statute. A law has a telos, it has an end, it has a purpose, it is directing us to something. What did the lawmaker intend to do here? What evils were they seeking to correct? What things were they trying to put forward? What would be the consequence of adopting various interpretations? Would it be absurd? Would it be ridiculous? Would it,
And then by asking those questions, you would say these laws should never be intended to be have an absurd result. So if you ask that question, yet the text might lead you in that direction.
right.
It
And
can't.
that's why, unsurprisingly, until pretty recently, when certain schools of thought started to attack doctrines like the absurdity doctrine, this is a canon of construction that is existed in our system long before it, and with effectively unbroken usage since the founding. And you might ask yourself, why is it that we, basically refuse to agree that a statute can produce a truly absurd consequence? And I think the answer is, well, because it is in the nature of law to be rational,
Sure.
and that is what judges do. They rationalize the law in pronouncing judgment and interpreting, and that's perfectly good. That is the right way to to approach things. The one other caveat I would add is that, and this is maybe the most controversial point, is that in the classical tradition, um, judges labor very, very hard to make sure that lex is in conformity with use whenever possible. But if it's not possible, this is where the real controversy,
What happens then? Yep.
and that we can go to Augustine, we can go to Aquinas, that we go to Blackstone, that a positive law that cannot be reconciled, that is to say, it in fact contradicts natural law, is no law at all, properly speaking. It's a corruption of law, and that this would be something in the classical world, that you cannot pronounce judgment according to a thing that's not law. Now, people love, students especially love to talk about this hypothetical. It gets more airtime than it deserves,
Yeah. Why would you
because
say that? Why would you say it gets more airtime than it deserves?
I think for certain rhetorical posturing, right? If you admit, which I freely do, that the classical tradition will ignore an unjust law, a truly unjust law, um, we'll go through a great deal of work to avoid that. Think of it like the way we think of constitutional avoidance, right? We use that doctrine to sometimes give interpretations to a statute that you might argue isn't the quote best one, but
Sure.
it actually is the best one, right? When it brings it into conformity with the greater structure of the law. Uh, the natural law works in a similar way, and the great bulk of the work of the natural law is in that sphere, in reconciling statutes to natural law principles, and quite rarely in the realm of, sorry, this thing is not law. This
So
thing
far
is,
outside, it can't even be considered law. So you're saying it gets more airtime because it's often,
well, it's more interesting.
it's the
and,
exception, not the rule.
yeah, and if you want to, for example, posture a critique against common good constitutionalism or the classical legal tradition, well, then you can say, well, look, they're just going to find things are contrary to natural law, and judges are going to go about striking laws down all the time, and I think that's a straw man. I think that's not in conformity with the tradition and the way the tradition conceives of law, but it very much is, and it's unfortunate that we live in a society where from time to time we may have laws that run up into sharp contradiction with the natural law. But that's a problem that we need to solve as society, and
Yep.
the classical tradition, I think, has a pretty clear answer to that. If there were a statute that said you shall commit murder,
Yep.
that one way or another, right? I think our judges would find a way to say it's unconstitutional, or something, right? But those kinds of efforts. Just one last point on this. Um, uh, it's not surprising to me that certain more capacious constitutional phrases, due process or what have you, can be the hook for these things. If we were to, I was having this discussion with somebody just the other day, but if, Buck v. Bell, which has never formally been overturned, this is the Supreme Court decision from the early 20th century that allowed state law here in Virginia, in fact, to have forcible sterilization of mentally handicapped people, and the Supreme Court endorsed that. It's obviously, uh, just this last term, Buck v. Bell took a lot of heat, and if the case were to come up squarely before the court, I'm quite confident that a majority of the court would say that such laws are unconstitutional. And they would locate the right to not be forcibly sterilized in the due process clause or the equal protection clause. They would find some theory. I think that's perfectly acceptable to do so, given the nature of use and lex, that we understand our law to be instantiating these broader principles of natural justice. And so I wouldn't be surprised, if someone were to say, a putatively originalist opinion that says, oh, well, the privileges or immunities clause actually positively incorporated a common law, natural law right to procreation in this limited sphere, at least, right? That you cannot be forcibly sterilized. I think the easiest answer is, of course, that forcible sterilization is contrary to natural law. Um, but that principle would find expression in broad texts.
Broader texts that have meaning based on these principles of the natural law of use that we can then read.
Yeah.
Yeah.
And the immediate objection, of course, is, aren't you, Professor Christensen, aren't these penumbras and emanations, right? In some sense, sure. But the point is that we have the principles right, not that we have the principles wrong.
Yeah,
And
is
that,
it a reason just to throw out the natural law because some get the principles wrong? And that's certainly maybe an easy objection, but is it the right objection? And it sounds like you would say no.
right, I would say no. That's the wrong way to approach it. That the right course is to choose the right thing and the right principles. And I happen to think that those are the principles. Um, not because I'm an ascriber to the theory of originalism, but our founders were thoroughly classical in the main.
Yeah,
This
let's
is
talk about that a little bit. You've brought that up, I would say a few times, and it sort of intrigues me. I think if I'm fair, it seems that the conservative legal movement adopting originalism on some level is just saying, well, we're just going back to what we've always done, right? This is our legal system. Originalism is the American legal system by and large, and we are restoring our our legal tradition, right? But you at least have alluded to this idea that perhaps our founders might not have saw it that way. What do you say? How did this look at the founding, and what would you say to that objection?
Yeah, I think there's two things. If originalists want to find the natural law having been positively incorporated at the founding, I'm not going to put up too much objection to that point.
You're okay with that one. Yeah.
My problem is when the theory of originalism and textualism then seek to, in practice and function, be positivist, to pay lip service to that, but then to say, no, we can't, consider principles of natural justice in interpreting a statute, or we can't consider the spirit of a statute, or we can't consider the consequences of an interpretation. That would be not doing law. There's a great inconsistency between those two views. I think the framers were had a different cosmology of the law
Mhm.
than we tend to have today. They had a classical one. These, from a juristic standpoint, they are greatly influenced by people like Blackstone and Montesquieu, who are thoroughly classical. When you read Blackstone's treatise on the nature of laws in general, in the first part of his commentaries, he you could be forgiven for thinking he had paraphrased Thomas Aquinas in talking about the hierarchy of law from eternal law to natural law to human law, or what he calls, civil law, but
Civil law, municipal law.
I'll call it municipal law because I'm Anglo-Saxon, and
That's
civil
right.
law, that's a little too Roman sounding, but that's what we call it. So we call it municipal law. That his conception of the hierarchy of law, of the relation between principles of natural justice and text, the spirit of the law and the text of the law, I think are all consonant with the classical tradition. And I think it's the way our courts operated, uh, and that there's not even really a very good response, in my view, to that. So
Hmm.
somebody who's certainly not a classical legal tradition guy, but a very famous scholar on statutory interpretation is Professor William Eskridge at Yale Law School. And he's, of course, famous for his conception of dynamic statutory interpretation. I disagree with this idea because it takes a different idea about, it seems to presuppose that when a judge is dynamically interpreting a statute, that the judge is engaged in lawmaking.
Sure.
And I would think about the question differently, and I think the framers would think about the question differently. That they would think, no, the question of the meaning, a consideration of text, context, consequence, purpose, principles of natural justice, etc., is the question of what the law is, not I'm making it better or making a different law or something like that.
The judge is bound by the law, right? This law that is, stands above them. These, you're saying, these first principles
Yeah,
they
that's
use.
how we know what the law is and what it means in a
Hmm.
particular case. But Professor Eskridge's work from the early 2000s on this doctrine called the equity of the statute, and he got into a discussion with now Provost John Manning about this, a sort of debate. But he has, I think, knocked down evidence of a principle that is directly tied to Aristotle's conception of what's called epikeia, which is the recognition that a, a statute, for example, may fail in justice in a particular circumstance. It might work some crazy outcome that we don't think the lawmakers would have intended, or in some cases it might fail to cover a situation that they obviously wanted to cover, but the text, strictly speaking, might not have gotten there. And I'm simplifying here. He doesn't consider all that to be epikeia, but I'm just simplifying. But that in the common law tradition, they call this the equity of the statute. And they would read statutes, these statutory cases, and they would say, I think this falls within the equity of the statute, the true meaning of the statute, even where the text of the statute might not have obviously, covered a particular situation, or conversely, um, that a statute, might seem to cover a situation, but they say no, that they didn't, intend for it to extend to this circumstance. And this was a widespread practice in the founding, in state and federal courts. And to my judgment, it's really only with later sort of, a rise in positivism, that these theories start to really come under attack, or these judicial practices come under attack. It's not to say that there weren't people at the founding who thought in positivistic terms. There are, people who had these ideas were coming along, right? Contrary conceptions of natural law that I think are erroneous were also prolific. But in our juristic tradition,
But in the main, in the juristic tradition.
the way our courts operated, I just think it borders on the undeniable that they
Mm.
were thoroughly classical. Um, and I don't think that I don't approach that to say, therefore, because I'm an originalist, I ought to do it this way. I see it as they were correct about the nature of law and judging, and I can therefore make an argument that I'm not doing something out of the ordinary in our own tradition when I advocate for those kinds of principles.
Fascinating, fascinating. So, we've covered a lot of ground. I wonder if we can just maybe, a few minutes.
Sure.
What does this look like at Regent? What do you teach here? How do we, we have a lot of prospective students who
Yeah.
listen to this podcast, and, why would people study here perhaps and not at other schools? And, what classes do you teach that relate to this?
Yeah. So I am very grateful to Regent for, from my understanding, essentially as long as the school has been in existence, the law school, as part of its Foundations of Law course, a required course for first year law students, they get an introduction to classical thinking. Aquinas is discussed, Blackstone, these kinds of ideas. Because, of course, as a Christian institution, there's the firm, correct belief in higher law and that God is the source of law. Right? We learn in Romans 13, right, that we should be subject to authorities. God is the ultimate source of authority. I teach a seminar called The Classical Legal Tradition and Natural Law. in which we go deep into these principles. We start with the philosophical concepts and the pre-Socratic philosophers, and work through Plato and Aristotle, and up through Stoic Roman tradition, and the legal, both the legal and philosophical side, the biblical tradition, into Aquinas, and then into kind of how I see these things in the founding. I, also use the work of Professor Brian McCall, teaches law in Oklahoma. Fantastic. He's done so much work on this. And also of Professor Adrian Vermeule in his book Common Good Constitutionalism, which provides sort of a theory of how to revivify these principles for contemporary legal problems. And so we go, very, very deep into those, and it's a really gratifying class. Students are really engaged with this and have, I think, a hunger for it. And so I think Regent's a great place if you want to learn about natural law. You can come here and take my class, and if you find me in the hallways, I will almost inevitably be talking about something related to this topic.
I'll tell you, I've been amazed at how many times I see you in the hallways or sitting down on the couch talking, debating with students. And I know from their testimony that they are enjoying thoroughly being able to have direct access to their professors, to engage in deep thinking, to challenge you and your ideas that they're learning, and to be, have a fair share of debating you. But I know many are also being, persuaded and hungry. And so it's been fun to watch that play out this year. Is there anything else? I think we've covered sort of the ground, at least. Maybe there'll be another episode coming here in the future. But anything else you want to add about classical legal tradition, natural law, that I might not have asked you?
Sure, it's very self-serving, but we can probably put it in the link in the description below, a link to my latest paper, which makes kind of the argument I've made here today, that I've sketched out in much more detail on SSRN, called "The Classical Legal Tradition as Our Tradition." And if people want to take a peek at that, they can read a much longer form.
A little more detail on our brief conversation.
Yeah.
Well, that sounds great. We will definitely post that article in the comments, and hope you all take a look at it. Thank you, Professor Christiansen. It's been fun chatting with you.
Thank
We'll
you.
see you next time.
Okay, we'll see you. Thanks so much.